This is Jake with RPS. I'm giving you an update that the New York State Section 8 law has been ruled unconstitutional twice by New York State courts. Here is some of the details and how it might affect you in the future as a self-managing landlord in New York. So back in 2022, the New York State Attorney General sued a landlord in Ithaca for declining Section 8 applications, and the local court ruled that the landlord was correct and was not legally required to accept Section 8 applications on the basis that we're forcing landlords to accept Section 8 vouchers puts the landlord subject to government inspections, which is a violation of the Fourth Amendment. Big news. So the ruling came down in 2023 that the landlord was not required to accept Section 8 on the basis of the unconstitutional search and seizure, amendment. So then the Attorney General challenged. So she appealed and brought the case to the New York State Supreme Court, which is you have local court, Supreme Court, Court of Appeals in New York. Court of Appeals is the highest court. New York's weird. If you're out of state, your state Supreme Court is the highest court, but New York State's different. So local court, landlord won. State Attorney General appealed, went to New York State Supreme Court. And in March, in 2025, March 5th of this year, the New York State Supreme Court ruled in favor of the landlord again. And the statewide now, the provision was struck down. So landlords were not required to accept Section 8 in New York State on the basis that it was subjecting them to unlawful search of their properties. Then April 2nd, New York State Attorney General appealed the decision. So what that means is that now she lost in the Supreme Court. She then appealed the decision, and now she's waiting for hearings with the Court of Appeals. That puts an injunction on the decision. So right now, the law is as it has been. So you are required to take Section 8. There's no change operationally for you today. This is important. The appellate division of the Supreme Court, the court names are just kind of confusing, but the appellate division of the Supreme Court's ruling is stayed while the appeal is pending. So because the Attorney General filed an appeal, the decision, the striking down of the original New York State law is stayed until the appeals court gets a verdict issued. So bottom line right now is you still have to accept Section 8 in New York State. Any landlord who refuses to accept Section 8 is subject to the same legal verifications you were before this New York State Supreme Court ruled. So no change today. What happens if the Attorney General loses at the Court of Appeals? So what they're striking down is not source of income. It is the inspection requirement under Section 8 applications. So if the New York State Attorney General loses again, then the exemption for source of income discrimination only applies to Section 8. So it's not like you can now no longer accept other forms of income. You are only not required to take Section 8 because of the inspection requirement, which is deemed unconstitutional by the court. So that's what happens if the AG loses again. Alternatively, the tenant advocacy groups are going to try to come up with a legislative way to amend the state laws to make the requirement no longer in contradiction to New York State law. This is what they did with good cause eviction. Good cause eviction was deemed unconstitutional under New York State law. And then tenant advocates changed New York State law, so then it was no longer unconstitutional. Okay. So that was a play. Maybe more complicated in this case. Remains to be seen what they're going to do. If the AG loses and advocates can't do anything about it, it could kick off a bunch of challenges nationwide. What you should do right now is continue accepting Section 8 vouchers like you always have been. It doesn't mean you have to take someone with it, but it means you are not allowed to deny them on the basis that they have one. That's very important. The law is stayed and it is enforced while the challenge is in process. So don't start denying Section 8 because of this recent ruling. Pay attention to the Court of Appeals. So if you want to stay current on this, you could keep looking up the updates. We'll have another update here when there's a decision. And then consult your attorney if you're going to make any policy changes. So big news for New York State. This is not really, this isn't going well for the AG and the tenant advocacy side if they lose this. But again, they have some other tools in their tool belt they may deploy. So I hope this is informative update. If you want more information, there's all kinds of links to the legal language in this document. You want to read through some of those, feel free. Thanks so much. I hope this has been helpful. And if you want, we have other resources that you can get access to. We have a free Rochester, New York landlord playbook. We have a free scope of work template, free rental analysis calculator if you would like that. And then, of course, if you want to hire us for full service property management, you can do all that with this little link here. All right. Thanks so much. Have a great day.